Hello everyone and welcome back to our channel. My name is Anda Malescu and I am the owner of Malescu Law, a law firm based in Miami, Florida. Here at Malescu Law, we specialize in serving companies, investors and entrepreneurs in the area of business, corporate law in Florida and immigration throughout the United States. If you need to get in touch with us, you have our contact information in this video and below this video. But before we get started, please subscribe to our channel by clicking the bell button or the subscribe button. Today we are going to speak about the differences between the E1 Treaty Trader Visa and the E2 Investor Visa. So without further ado, let's get started. The key differences between the E1 and the E2 visas are: 1. Only citizens of certain countries can apply for an E1 visa, and some countries have an E1 treaty or an E2 treaty with the United States, but not both. So, for example, in the case of Bulgaria, a citizen of Bulgaria can apply for an E2 investor visa for the United States because the United States has an E2 treaty with Bulgaria. However, the same citizen of Bulgaria cannot apply for an E1 visa for the United States because the United States and Bulgaria does not have an E1 treaty. Also, for example, in the case of Greece, a citizen of Greece can apply for an E1 visa for the United States, but not an E2 investor visa for the United States because the United States only has an E1 treaty with Greece but does not have an E2 treaty with Greece. Or, in the case of Japan, a citizen of Japan can apply for both an E1 visa or an E2 visa because the United States has an E1 treaty and an E2 treaty with Japan. Two, the E1 visa does not require a financial investment in a U.S. business. In the case of the E1 Treaty Trader Visa, you must show that the trade between your E1 treaty country and the United States is substantial and is primarily with the United States. While substantial trade is not a set dollar amount, it should be at least $100,000 in terms of the value of the trade with the United States. On the other hand, in the case of the E2 investor visa, you must make a substantial financial investment into a U.S. business that is active and is likely to hire U.S. workers in the near future. Again, the substantial financial investment is not a set dollar amount, but it should be at least $100,000, but it can also be less or more depending on the specific business that you plan on running in the United States. 3. The E1 Treaty Trader Visa does not require a 5-year business plan. While a business plan is not required with the E1 Treaty Trader Visa, it is still highly recommended to include a 5-year business plan with your E1 visa application. Keep in mind that for the E1 visa, you are not required to show that you will be hiring U.S. workers in the near future. This is unlike in the case of E2 visa, where you are required to present a 5-year business plan for your E2 business when the business is a startup and it has been in operation for a couple of years. And you will also need to show the capacity to hire U.S. workers over the next 5 years when you apply for an E2 investor visa. And finally, the E1 Treaty Trader Visa does not require the formation of a company in the United States. However, it is still recommended that you form a company in the United States before applying for the E1 visa at the US consulate or embassy abroad, or in the United States with the United States Citizenship and Immigration Services. This is all for today. Thank you so much for watching. Please subscribe to our channel, and if you need to get in touch with us, you have our contact information in this video and below this video. We will see you soon. Bye.